Good morning, everyone. This is Tim Lohrentz from the Insight Center, and we're very glad to have you here. Good afternoon for those in the Central or Eastern time zones. And we're very happy to have a webinar on Proposition 209 and public contracting and purchasing in the Proposition 209 era. And it's really a legal review of some of the options that states and cities and counties will have in a framework like Proposition 209. Just a few housekeeping things for those of you on the line. If you can choose to participate either with the sound system within your own computer or by dialing into the computer, and if you go through and dial the all the different codes and controls, the 2-digit PIN number, we will be able to unmute your phone and allow you to ask any questions at the end directly. If otherwise, we will, if you do have questions, you will need to type them in the question box, and we can ask the questions for you. But if we are able to unmute your phone, if you have and we have that audio control here, we can do that, but you will need to type in the 2-digit code for it to allow us to do that. So there's also, there will be time, there is a box where you can raise your hand, but generally we will not be taking questions during the middle of the presentation, so that could be used. We encourage any questions just to be written down in the question box rather than raising your hand. There might be a few times during the presentation we just ask for hands to ask if we have kind of a general question and want to see if somebody has heard of something or something like that. So I think that's the main questions, the main instructions right now for the webinar itself. And the research report that this is based on is on our website. We will not be sharing the slides per se, partly because of the legal nature of the slides. We'd rather have the legal review in the full paper to be what people take home with them. And so that's the reason we will not be able to share the slides themselves of this presentation. And just one other note, we are happy to have the National Association of State Minority Women and Disadvantaged Business Enterprise Directors as a co-sponsor of this event, and it's a professional development activity for that association. I'll be saying a little bit more about NASMWID, the acronym for that association, in a minute. So we have the main presenter today will be Julian Gross, who's the lead author of the study, and I'll be introducing him a little bit later. And we also have a respondent, Colette Holt, and I'll be doing an introduction and a little bit in between Julian and Colette as well. So the Insight Center is a 43-year-old national nonprofit, and we are dedicated to help vulnerable communities to become and remain economically secure. We have program areas in workforce development, early care and education, asset building, and helping, again, economic security is one of our main areas. And we also, this project is part of the Closing the Racial Wealth Gap. The Inclusive Business Initiative is our initiative specifically to help minority and women-owned businesses. And our main area that we work in is research and technical assistance, as well as convenings to create programs, best practice programs that further the growth of minority and women-owned businesses, as well as micro businesses. And our co-sponsor for today, the National Association of State Minority Women and Disadvantaged Business Enterprise Directors, is made up of directors and managers or coordinators of these types of programs within state government structures. including within the DOT, the Disadvantaged Business Enterprise programs. It's a little less than 2 years old, and it's to elevate best practices within the field, within MWDBE procurement and business development. And it's also to create a national body that can talk with and speak for these directors and these programs at a national level, and including with the federal government. And also it's to create professional development activities for its members. All right, so today's topic is about Proposition 209, and it was a ballot measure that passed here in California in 1996, and it's basically an anti-affirmative action measure which took out any mention of race or gender, basically in higher education, public employment, and public purchasing and contracting. 5 states have passed measures like this: California, Washington, Michigan, Nebraska, and most recently Arizona. There's potential for a similar measure in Oklahoma in this election year. The one victory that there's been on this has been in Colorado, where voters defeated this type of measure in 2008. And behind all of these ballot measures has been the Pacific Legal Center in Sacramento here in California, which is headed by Ward Connerly, and that's sort of been the common denominator of these ballot measures as they've been across the country. And you might notice that their efforts have been concentrated in the West and in the Midwest, and that's where they've seen the easiest states to pass such ballot measures. And the impact here, of course, there was a lot of impact in public employment, but especially in higher education has probably been the most severe impact. And there's actually a court case that was in the news yesterday here in California, that there's a pretty prominent court case that's been initiated related to public education, but also in the topic for today, public purchasing and contracting. And it wiped out the state program. The state had a pretty significant affirmative action program within state purchasing, and as well as in over 15 cities and counties across the state where programs were ended. A few cities like San Jose tried to continue their programs, and we'll hear more about this case in the legal review, and that program ended at that point. Los Angeles is one place that was able to maintain its program, although it's from the start it has been a race and gender neutral program, albeit an innovative one. And in addition to the programs themselves, the infrastructure around those programs, such as certification of firms and also tracking procurement dollars going to MWBEs, that was also ended as part of Proposition 209, even though it wasn't necessary for that to happen. We previously did research that showed that all minority and women-owned businesses, on average, suffered due to Proposition 209 with lower growth rates than their counterparts in other states. And so this was true even among businesses that did not do business with the state or with the local governments. So there has been an impact at the firm level from this proposition. So we saw a need to do this study because, as we said, pretty much every local agency, every local city or county ended what they were doing, and some were not doing anything in the first place. And from a legal perspective, they were doing a lot less than they could be doing. And so you see a lot of minority and women-owned businesses have really suffered. A lot of even local businesses of any type have suffered because of kind of the end of all of these programs across the state. And there's sort of an attitude that we see in local government here of everything is, or anything is infeasible or illegal in terms of trying to add some inclusion to some of the purchasing policies. And we found that the major stopping point in many places has been the city or county attorney's office. So sometimes even when there's political will, that it doesn't really matter because the city or county attorney will stop any type of action. And so a lot of this is due to here in California having the presence of Pacific Legal here. That's a major threat to local governments. And so you see a lot of city and county attorneys being extremely conservative because they want to avoid any sort of challenge from Pacific Legal. But this is, for that very reason, we saw the need to create a legal study to challenge the opinions of attorneys, as well as to really back them up, so that if they are wanting to do something that's more inclusive, that they have a resource and a guide that they can go to that will back them up to that they can move forward with. And just one other thing before we get to Julian Gross's presentation, but I wanted to say, just for those states that are not among the 5 that I mentioned and do not have Proposition 209 type of measures, why is this relevant for you? Well, for one thing, if you have a race and gender neutral program, there actually are a lot of innovations happening now in California that might be worth looking at and implementing. And because of the limitations placed on local governments here, there's actually been some innovation, I would say, at that within small business and local business enterprise programs and I think some of the jurisdictions are worth looking at. And secondly, in a lot of places, you may not have the political will, even if it's legally possible, you may not have the political will to set up or maintain a race and gender specific program. And so then your choices will be limited to the types of programs that you'll be hearing about today, and this will help give some idea of the legal standing of those programs. What can you do or what can't you do without a disparity study, for example. And finally, we see that a good race and gender neutral program is better than no program at all, although we think it's important to continually point out the limitations of that approach, that really the best approach is the one eliminated by Proposition 209, which is either a prime or subprime contracting goals-based program is really the best approach. But so I think it's important to do something, but like I said, to continually remind people of the limitations of that approach. So at this time, I'd like to introduce Julian Gross, and he's an attorney who advises public entities and nonprofits on community benefits agreements. He's also been very active in the field of public procurement. He was the director of the San Francisco Independent Task Force on Affirmative Action of Public Contracting. This provided a detailed review and recommendations for improving the administration of San Francisco's contracting policies. And we were very happy to work with Julian in completing this legal review. So, Julian.
Thanks, Tim. Thanks to Insight and our other sponsors for letting us have this webinar. It does seem like there's a huge amount of misinformation out there, and as you mentioned, Tim, there's just been a dramatic change in California, both in terms of policies and in terms of effects on MWBEs after the passage of Prop 209. But it's sort of particularly disturbing to hear these multiple reports about legal objections being raised that really go beyond the scope of Prop 209. So we're glad to have this opportunity to try to cast a little clarity in this area, we hope. So the brief that we've just published, the bulk of it is a thorough legal overview of what we've seen out there in terms of program elements that public entities can use, and dividing those program elements into three pretty obvious categories: permitted under Prop 209, possibly permitted, and prohibited. We are going to spend the bulk of this part of the webinar, as we did with the brief, on the things that are permitted under Prop 209, both because they're the area that prompted the publication of this brief and this webinar, but also because it's a lot more complicated. There are just a lot of things we can talk about in terms of what's permitted, whereas the possibly permitted is a pretty small category, and what is prohibited is crucially important, but is pretty clear with some sharp lines around it, so we don't need to spend too much time on that. A couple things I want to note: we are only discussing programs legality under Prop 209. Obviously, there are other issues that are out there. Yeah, the Equal Protection Clause, I'm sure most of the attendees here are well aware, imposes some standards that you have to meet if you're doing a race and gender conscious program. We also want to know, I want to emphasize, as Tim just did, that as much as we like to talk up these programs that are legal under Prop 209, they're not a substitute for the range of options that public entities would have in the absence of Prop 209. If the policy goal is to advance and prevent discrimination against and remedy past discrimination against MWBEs, obviously the most direct and effective way to do that is going to be a program that targets them directly. We don't have that option anymore in California, and in other places there are political limitations on what you can do. So it is important to explore these things, but also important to remember that the better programs would be in the absence of Prop 209. You should note that there's not a lot of case law interpreting Prop 209. It's a little surprising. It's been 15 years. The California Supreme Court has only addressed it twice, and there are some lower court decisions, but not that many of them, and they're mostly not in the realm of public contracting. Prop 209 covered employment, education, and contracting, and most of the cases are about the education area, which raises some particularly interesting issues, but doesn't apply perfectly to the contracting setting. One other legal issue that's extremely important and is pretty undeveloped is the relationship between Prop 209 and federal law. So we'll spend a lot of time on that in the next 20, 25 minutes. So as we go to the next slide, just very quickly, the basics on Prop 209, adopted by the voters of California through the initiative process in 1996. The key provision is, as set out there, the state shall not discriminate against or grant preferential treatment to any individual group on the basis of race, color, etc., in the operation of public employment, education, or contracting. The key phrase there is preferential treatment. So our question is, what constitutes grant of preferential treatment? And when I say race and gender, I'm using that as a shorthand for this range of categories. There are also a couple exceptions written right into the text of Prop 209. Those are on conditions of receipt of federal funding. So if a federal funding entity actually requires use of affirmative action on a particular project, then that insulates that action from Prop 209. As I discuss this, I'm going to be using the term affirmative action for an explicitly race or gender conscious program. I know some people use that term a little more broadly. There's also an exception for court orders and consent decrees, which is a little odd because it's sort of an indication that in certain situations, as a remedy for discrimination, you're going to need to engage in affirmative action steps. So you'd like to see public entities be able to do that as a means of avoiding litigation rather than having to get sued and then settle it through a consent decree or lose and have a court order and then they're allowed to do it. So moving on to the next slide. So the two cases we're going to talk about are the California Supreme Court cases, high voltage wire works. This was the leading case, the first California Supreme Court interpretation of Prop 209. It came down in the year 2000. The city of San Jose had what you saw as sort of a classic standard goals and good faith efforts MWB program governing subcontracting awards. So prime contractors had a choice of how to comply with their program. They had to either attain the subcontracting percentage goals or show that they took good faith efforts to meet those goals. So they, in an effort to try to present a good case on Prop 209, the City of San Jose clearly separated out those two pathways to compliance. So they had a goal attainment option and an outreach option. The court struck both of these down. I think some of the advocates had hopes that a pure outreach requirement directed at MWBEs would be considered not a preference because it's expanding competition, it's not excluding anybody, but the court struck that option down on grounds that it provided a preference to MWBE subs who would get outreach that non-MWBE subs might not get. What this decision didn't do was address an approach that a city could take requiring outreach both to MWBEs and also to OBEs, other business enterprises, namely white-owned businesses. So that is actually an option out there and one that we'll talk about a little more as we go down. So next slide, please. Coral construction is a very important and much more recent California Supreme Court case. This came down in 2010. The city of San Francisco had aggressively defended and maintained their affirmative action program after the passage of Prop 209. The city had both a prime contracting bid discount program and a goals and good faith efforts subcontracting program similar to the San Jose program we just described. One thing that really set San Francisco apart was its extensive factual evidence of discrimination that it put together. So it commissioned disparity studies, and it found extensive evidence of affirmative discrimination against MWBEs, both in prime contracts awarded by the city and in subcontracts awarded by prime contractors that receive city contracts. So there were several arguments San Francisco made to try to maintain its programs. The court rejected facial challenges to Prop 209 based on the Equal Protection Clause and also the political structure line of cases. If people want to, in the Q&A, we can talk a little more about the political structure line of cases, which has been addressed a couple times, but is being raised in the Ninth Circuit case that Tim mentioned in the introduction. So as we go to the next slide. So there's a crucial holding relating to the relationship between Prop 209 and federal law. This is the Supreme Court validating an argument that advocates of affirmative action programs have made for a long time, which is that when there is extensive evidence of identified past discrimination by the actor in question, and you can show that the only way or the most effective way to remedy it is through affirmative action, you can basically consider that a requirement of federal law that a public entity undertake that action, and it's thus insulated from Prop 209 due just to the supremacy clause. So the Coral Construction Court basically endorsed that argument. So we'll talk a little more about the exact standards they imposed to show that. But the basic holdings are that federal law can at times actually require, not just allow, but require a preferential race or gender conscious bid discounting or subcontractor utilization program. They also noted the extensive evidence I mentioned that San Francisco had gathered and said that this type of evidence is the type that might establish such a requirement. And then it set forth rigorous standards for this determination, which we'll talk about below, and remanded the case to apply those standards to San Francisco's evidence. So as we go to the next slide. All right, so now we're going to get into the categories of program elements I mentioned. There's the three categories of permitted, possibly permitted, or prohibited. Our determinations of what's put in these different categories are based on the high voltage case and the Coral Construction case we just mentioned, and also these lower court decisions, as few as they are, and also just the logic of discrimination law and the relationship between federal and state law that's sort of established by a range of cases across a few different types of industries and programs. I should note that we're not evaluating in this categorization programs that can have sets of different elements. We're looking at the individual program elements, which can be combined. The best programs, are certainly after Prop 209, are going to combine a range of these approaches. And you'll see when we get into them that it's be very easy to put a local business preference program together with aggressive outreach and bonding assistance and so forth, and in an effort to have a good, effective, thorough program. And the program elements really have, you could look at them differently from a legal perspective. So some elements might be more risky or on safer ground than others. So we thought we should break it into particular program elements. Once again, we're evaluating only under Prop 209 and not competitive bidding rules or local charters or anything else. And there are a lot of examples in the appendix to our brief, which Tim is going to talk about a little bit after I'm done. Next slide, please. All right, so the first category, permitted under Prop 209. I hope this slide is not too complex for you guys. I wanted to really emphasize that any program element that does not explicitly involve race or gender is permitted under Prop 209. As you'll go down, you'll note that any program element that does not explicitly involve race or gender is permitted under Prop 209. This is really worth emphasis because this is the core limitation of Prop 209, or the core sort of marker of Prop 209 under its plain language, but it's often ignored by city attorneys who think that if you did an LBE program that was going to have an effect, that it benefited a lot of MBEs, that might be limited under Prop 209. Or they take the preference language of Prop 209 to say that any preference for anybody, even if it's race or gender neutral, might be excluded or prohibited by Prop 209. So this is a really important element, and you wouldn't think we'd have to emphasize it so much, but it's a key concept, obviously. So if we go to the next slide, once again, you'll see I wanted to emphasize this. All right, if we go to the next slide, what is permitted under Prop 209 if you apply that principle that we just went over? Race-neutral contracting preferences. This is a huge category. We're not going to spend a lot of time on it. You'd really need another webinar to discuss all the wrinkles here. But you've got small and micro business preferences. You have local business preferences and local employment preferences. All of these have examples around California and around the nation. All of these will probably at least increase to some degree, if the program is run well, the amount of contracts going to MWBEs. Small and micro business preferences, it's particularly important to look at the threshold that you're doing there. A lot of MWBEs are small enough that if you don't have a really small preference threshold, then you're just not going to capture them. Local business preferences sometimes have other legal issues, but are obviously much more feasible from a legal perspective than race and gender conscious programs. And local employment preferences people don't usually think of. So this would be preferences for businesses or requirements that businesses receiving public contracts employ a certain number of local workers. So there's a range of other legal issues regarding these types of programs, but those issues can be resolved. You can require use of workers that reside in low-income neighborhoods and so forth. So that's obviously not a direct link to MWBEs, but in many industries, MWBEs are going to have a higher percentage of local workers or a higher percentage of targeted workers from low-income neighborhoods than non-MWBEs, so you could serve that function as well as the popular policy goal of directing employment opportunities to local low-income workers or neighborhoods. Then, so that's a big category that we could spend a lot of time on, but just to go through all the options. Inclusive outreach programs I mentioned before, the high voltage, some of the language in the high voltage decision and some subsequent case law indicates that if you have a program that requires outreach to MBEs, WBEs, and OBEs, that does not violate Prop 209 because basically every group is being treated the same, so it's not preferential. On this point, many outreach obviously doesn't guarantee that you're going to get any contract, but particularly when this is applied to a subcontracting program, making sure that prime contractors provide MBEs and WBEs as well as OBEs with notification of subcontracting opportunities. Many MBEs think that that can be quite helpful, that the common complaint is that prime contractors have a set of subs that are usually OBEs that they usually work with, and that MBEs and WBEs don't get a chance to bid or develop those relationships. So these inclusive outreach programs can break down those barriers and act as an effort to sort of given opportunities to develop those relationships. So going to the next slide. All right, so this is a crucial category. This is also permitted under Prop 209. It's probably one of the most important and effective things that, that public entities can do, and that is take a close look at the selection processes and the bidding and performance requirements and make sure that they're all really necessary, and try to make sure that, that those kind of processes go as far as they can to ensure a broad pool of bidders. Insurance and bonding levels are very frequently cited as a barrier to small MWBE business participation in a project. And so what public entities should do is look closely at those requirements and make sure that they're really set at the necessary levels. So obviously no one's encouraging public entities to not have those requirements or not have them at a level that protects the public and the public entity, but to look at those levels and to make sure that they're really set at necessary levels. You also often hear about efforts to break large contracts into separate smaller contracts to allow a wider range of small businesses to compete. You can broaden outreach efforts and make sure that everybody is providing sort of better information about bidding opportunities. You can use the web for this. You can just sort of better publicize these things, and that helps get a wider pool in there. You can also require bidding out projects again if the number of respondents is small. Some prospective bidders, particularly MBEs that don't usually work on public projects, would benefit from some proactive assistance from the public entity to make sure that their bids are responsive, that they know where to go for support in terms of the bonding and insurance and other requirements. And you can, in fact, base performance reviews or commend contracting officers when they have succeeded at doing these things and got a wide range of bidders in there. So all of this is aimed at just making sure you get the broadest pool possible and you're actually helping businesses try to compete for these things. And none of these are race conscious or violate Prop 209. Going on to the next slide. Similar steps you can take that are race neutral and are going to be helpful would be publicly sort of crediting or commending contracting officers and primes who increase MWBE utilization. So that's an example of something where race consciousness is involved in the step of commending a contracting officer who increases MWBEs, but it's not a preference to a particular business. And there's some good language in lower court cases indicating that public entities don't really have to disavow utilization of MWBEs as a policy goal or as a public benefit. There are certain things they can't do, but they don't have to pretend like the issue doesn't exist or that it doesn't matter to them. So this is something that they can do, which fosters a culture and validates the perception that this is an important policy goal. Keeping going down, you can take affirmative steps to help MWBEs connect with a trade association, which can help with purchasing insurance or other kind of pooling efforts, as well as important networking efforts. The public has an important role there. You can, in fact, certify firms as MWBEs. This would seem odd if you don't have a program that requires use of certified firms, but other entities and private parties may have those programs. Or they could foster voluntary steps that a prime contractor might take if they wanted to have more MWBEs. A certification program, as a lot of you know, is not an easy thing to run or a cheap thing to run. But so larger jurisdictions that have the capacity and have experience doing that can perform a real service to MWBEs by having a good certifying program. And then very important is this last bullet, which would be efforts by public entities to create programs that either help with bonds or loans or insurance so that small businesses that don't have an easy time with those things have a public source for that. That, of course, doesn't have to be race or gender or limited to MWBEs in order to be quite helpful to them. Going to the next slide. All right, so then the topic we mentioned before, we're going to just cover very briefly through a few slides. And this is situations where affirmative action is actually required by federal law. So this is probably the most complicated legal issue around Prop 209, so that's why we're going to spend a little time on it, even though it applies only in certain circumstances. First is when it's required as a condition of receipt of federal funds. The court in Coral Construction noted that this needs to be a very clear requirement, that if the federal regulations or the instruction from the federal entity sort of gives a range of options, some of which are race neutral and some of which are race conscious, that under Prop 209 the local entity is supposed to choose the race neutral way. However, there are certain situations where a federal funding source may in fact require race-conscious actions, which then are insulated from Prop 209. So an example of a program where occasionally race-conscious actions are required is the USDOT's DBE program, 49 CFR Part 26. I think Colette will probably talk a little more about this during her respondent session. She's truly expert in this area. But some of the basics of it are that recipients have to set utilization goals. They have to run their program by USDOT. And in some cases, maybe Colette can talk about when race and gender conscious action may be required in order to achieve those goals. So that's a big one for public entities that receive DOT funds. Another time when federal law may require affirmative action is when, in the situation we talked about with Coral Construction, where it's actually required by the Equal Protection Clause. So previous Supreme Court cases have made clear that obviously public entities can't engage in affirmative discrimination themselves, but also that they can't, quote, passively participate in discrimination through funding. So that would mean that if they're continually funding a set of prime contractors or a particular prime contractor, and they have evidence that that contractor is engaging in racial or gender discrimination in selection of subs, they can't just keep doing that and funding that discrimination if they know about it and could stop it. As I mentioned, Coral Construction went through the standards for when this is actually a requirement of federal law to the point that Prop 209 doesn't apply, and they need to go ahead with these types of programs. So we get to the next slide, please. All right, so here are a couple key points from Coral Construction. I'm quoting up there the precise site. So it says the relevant decisions hold open the possibility that race-conscious measures might be required as a remedy for purposeful discrimination. That's purposeful discrimination by either the city or the prime contractors. The major standard is that there needs to be a strong basis in evidence in order to justify a program. The program has to survive strict scrutiny because that's what it needs in order to comply, to be even allowable under federal law, much less required, as we're talking about here. And then another important quote is that proof of discriminatory purpose or intent is always required to show a violation of the Federal Equal Protection Clause, and remedial action must actually be necessary. That's a quote from the Supreme Court in Coral Construction. I'm not sure I agree with the premise of that quote, that you always have to show discriminatory purpose in order to show a violation of the Equal Protection Clause, because there is a disparate impact line of cases. But when the court was setting forth standards here for insulation for Prop 209, that's how they laid it out. So if we go to the next slide, we're going to talk about the very particular set of standards that Coral Construction set forth for what San Francisco would have to show to have their program upheld in the face of the Prop 209 challenge. One, the city's purposefully or intentionally discriminated. Two, that the purpose of the ordinance was to remedy that discrimination. Three, that the ordinance is narrowly tailored to achieve that purpose. And this is important. Number four, that a race and gender conscious remedy is necessary as the only or at least the most likely means of rectifying the resulting injury. So that's pretty strict, but as I said, San Francisco has some very compelling and very thorough evidence about discrimination in public contracting, which is what happens when you don't have these programs in place, and sometimes even when you do. So the case is on remand, and we'll see when the lower courts apply these standards to San Francisco's evidence, whether the program survives. Next slide, please. All right, another hugely important category of things that are permitted under Prop 209 is anti-discrimination efforts. So this is just a catch-all category for everything that a public entity can do to avoid discriminating itself, that is, avoiding engaging in race or gender discrimination in its contract awards and to make sure that primes that it is funding don't discriminate as well. Any lawyer who has tried to think about bringing a discrimination case or has brought one will tell you that the essential underpinning, the crucially important thing is data collection, is knowing what is actually going on so that you can slice the data and look for patterns. So data collection is something that the public entities absolutely need to engage in if they want to be serious about this. So this isn't an easy effort, but it is very important, especially for large public entities. So they should be requiring bidders for prime contractors as part of submission of a bid to state the proportion of their subcontracts to be performed by MWBEs and by OBEs. So that does not violate Prop 209. It seems like something that some city attorneys might object to, but I don't think there's any argument that that violates Prop 209 to require them to report how much they're using, because, of course, you're under a legal obligation not to fund discrimination. And then as the project goes forward, the prime contractors should continue to be required to report the portion of the subcontracted work that was actually performed by MWBEs. This, of course, would lead to a mountain of data. You would need some aggressive data analysis. So it seems like a big step, an expensive and burdensome step by a public entity to collect all this data and analyze it. But of course, that's what they're doing when they're engaging in and funding disparity studies to try to promote these programs. It seems equally important and plausible that they could do this in order to prevent discrimination. And then, of course, we look at that data and you would give primes or industries or contracting officers additional scrutiny when troublesome patterns emerge. So if a prime contractor is constantly never awarding any subcontracts to MWBEs, you would look at that as a contractor that needs additional scrutiny, and you would look at how they actually select their subs. Next slide, please. All right, now we're jumping to the much shorter category 2. We're going to cover these last couple categories pretty briefly because they're much more simple. The reason this, so two things that are possibly permitted by Prop 209 are would be a goals good faith efforts program similar to the one I described for San Jose, but with an OBE requirement as part of the goals and good faith efforts. So under this type of program, you would have an MBE utilization goal, a WBE utilization goal, and an OBE utilization goal. So of course, when you add those three things together, you've got you're not going to add those together and have the goals equal 100%. You're going to want some minimum utilization rather than it being precise. But the legal argument would be that by treating all three of these groups equally, you are just trying to ensure that everyone's getting an opportunity and that it's not preferential to any group because they all have goals, and the goals, of course, need to be set by some analysis based on an analysis of the data and what is a reasonable goal for those different industries. So this is a creative approach. I think it's an aggressive approach, and there are some entities within California that are undertaking that approach now. And as far as I know, none of them have been challenged in court. So that does seem like a promising effort. Then you also would need another approach that's possibly permitted by Prop 209 would be saying that you need to get at least a certain number of bids if you're awarding a contract from MBEs, from WBEs, and from OBEs, and that you would send it out to bid again if you didn't get at least one from each of those. So that's akin to an outreach requirement. I think there's a good chance that that would be upheld, and it would at least make sure that you're trying aggressively to get every type of group engaged enough to bid on a particular contract. So I think the reason that there's such a small number of things in this category of possibly permitted by Prop 209 is that the basic rule of Prop 209 that it has to be race or gender conscious is so simple in a way. It's kind of a straightforward rule. There's a few things that are right on the border, like the two that I just mentioned, but most of the things I've talked about, like anti-discrimination approaches, LBE programs, broadening outreach, bonding programs, just don't come into play at all with Prop 209. So that's one of the main messages of this publication and webinar. Finally, Category 3, what's prohibited by Prop 209. This is pretty clear from the high voltage case. You can't have bid preferences, discounts, or set-asides that are limited to MWBEs. You can't have requirements, according to high voltage, that contracting officers perform outreach to MWBEs and not to other groups. Subcontracting, similar pair of prohibited activities. You can't have requirements that prime subcontract a certain amount of work to MWBEs or show that they tried to do so. That would violate the high voltage holding. And also, high voltage established that you can't just require primes to perform outreach to MWBs without also requiring they perform outreach more broadly. So pretty simple categories in contracting. It gets a lot more complex in education, but that's outside the scope of this webinar. So next slide, please. Yeah, and I think we're going to turn now back to Tim for a few highlights from some of the material in the appendix of the brief that looks at the various, some various examples from around the country of these types of programs, often combining elements I've just talked about.
Thanks, Julian. And we want to talk just about a couple programs, and both of these that I'll mention are really sort of in the middle category that Julian mentioned, where they may be permissible, and it really depends on the details of the program of whether or not it would be allowed under Proposition 209 or Initiative 200 in Washington State or similar measures. And but it's some of these programs that are in that middle category that are actually hold the most promise and that are the most interesting and innovative. So it's some of the places that have sort of pushed the envelope of what can be done. And the first one we'd like to highlight is a supplier diversity program modeled somewhat, I would say, on a corporate supplier diversity model. And this is being done by the state of Washington under their Initiative 200. And it basically is creating a culture of inclusion throughout each agency in the state in terms of their purchasing and contracting, so that that culture of inclusion drives more contracting dollars to minority and women-owned businesses. So it's sort of an internal remake, an internal culture change that's really driving that change rather than a set of regulations or laws. As part of that culture change, you see some specific pieces of it, but it really doesn't make sense unless you understand it in kind of that broader context of trying to change the perception, the attitude, the manner in which all of the various state purchasing agents do go about their business as they are doing purchasing or setting up subcontracting documents and processes within the state. So this includes matchmaker events where you bring together a large number of MWBE firms, state purchasing agents, and as well as prime vendors all together, so that there's an ability to have access to the people making the decisions, whether it's on the part of the state or on the part of prime contractors. A second one is to simply increase the pool, and so that there's a higher possibility that minority and women-owned firms will be selected. And basically the idea is so that the vendor pool is as diverse as the taxpayer pool. And the third piece of this is that each agency has its own supplier diversity plan. It has its own coordinator for supplier diversity, so that there's a plan of action that takes place in every agency. Every agency has a goal that they set, of an aspirational goal and it's generally based on improvement over the previous year, rather than as a certain percentage goal, and it may vary from each agency. And then there's some sort of system of accountability, and this is really important, where there's some somebody is held accountable for the performance of each agency as they are attaining or not attaining their plan and their goals that they set out for their agency. And that can go in some places that has gone as high as the governor, him or herself, talking with agency heads on a regular basis about their supplier diversity numbers. And there's also a positive incentive, which can be done, for example, through an awards ceremony. On the negative side, you can actually publish the performance of prime contractors in terms of their percentage of their subcontracting that goes to minority and women-owned businesses. You can give them grades, and so it's sort of, again, both positive as well as negative, depending if they would get an A versus an F. And it actually is possible to initiate a Title VI investigation under the Civil Rights Act of any prime contractor who gets an F for X number of years in a row, just as an example. So those are some of the different pieces that can go into a supplier diversity program. Then there's some of the innovations that you find within small business programs, and Julian went into some detail on this, so I won't say too much more about it, but it's basically where you, and the one innovation is embedding minority and women-owned businesses within an SBE program, a small business program. And the one example Julian talked a lot about is from the city of Los Angeles, where there is a minority, women, and other business enterprise program. And so that there are specific goals for each of those categories, and there's specific outreach to each of those categories. And as long as it's happening with the OBEs, it can also happen with the MWBEs. I believe that the city of Los Angeles is actually moving away from that program for, not for legal reasons, but I think just for practical reasons. They want to try a different approach. Commonwealth of Virginia has a similar approach as part of their small business program, SWAM, Small Women and Minority Business Enterprise Program, where there are specific goals for each category of small women and minority within that program. And then the other place where you see some innovation here in California taking place is within some of the local small business enterprise, and especially where you combine the local with the small. It's probably the most innovative. City of San Diego and LAUSD are worth looking at. And then also you can, within a small, you can embed an emerging or a micro business as part of that, and so you have a separate goal for those smallest businesses. A lot of times the small category, if it's defined like the SBA, actually it can be found to be almost too big for some industry sectors. And then if you are able to begin tracking the MWBE, for the type of their participation within those programs, I know that's been very useful, for example, with the city of San Diego in the last few years. So we're going to take a break here. I see that a lot of people are putting in your questions. We're going to move on to our respondent, Colette Holt, but I know a bunch of people have been asking about the slide presentation itself, and I can say again that we are unfortunately not able to offer the slide presentation on our website or elsewhere, and it's again due to the content, the legal content, that we prefer to have the full details of the legal description of the legality of these programs available. So we much prefer that you download our actual full report that is available online at our website rather than making available the slides themselves. However, we are recording this webinar, so the recording, which includes the slides themselves, is available or it will be available after the webinar. So that is one way that you can access this information after the webinar is finished. Okay, so here's the email addresses of the 3 participants, as well as our website of the Inclusive Business Initiative, which I just mentioned, where the research report is located. And at this time, I'd like to introduce Colette Holt, and she's one of the foremost experts in diversity studies in the United States, and has worked with many states and local entities on their disparity studies. And she's also been an author of trying to set some standards at the national level on how how disparity studies should be done. And we look forward to your comments, Colette.
All right, thank you, Tim. Can everybody hear me? Yes? Hopefully I'm not.
Yes, I think so.
Okay, great. And thanks to everyone who's on this webinar. It was a lot of fun and an honor to work with Julian and Tim on this project, and they put together a great advisory group, of which I was a part, and lots of other people weighed in as well. So we thought it was important to support the work of the Insight Center to provide this type of guidance. I've lived in California now for all of 5 months, and so it's a very different experience out here than many other places in the country that don't have the strictures and restrictions of Prop 209. But it's important, as Tim mentioned earlier, that even for those of you who are in jurisdictions that don't have these types of prohibitive constitutional amendments, that you can take some of these ideas to enhance whatever you're doing on your state and local programs, even if they are, in fact, of a more traditional MWBE type. I sort of had to laugh when Tim called me a respondent here for their lawyers on the phone. That makes it sound like I'm actually in some type of an opposition to this, and that's certainly not true. I'm totally supportive of what they're doing. I think that probably comes from the fact that when we were working on this project, I was the person mostly saying, well, but you know, these really are not a substitute for a real race and gender conscious program, and we need to be very clear about that. That comes through shining in the document itself, and both Tim and Julian have mentioned it several times. But it is important to recognize that we really don't have very much data at all about whether or not these types of race and gender neutral small business approaches work. As Tim mentioned, I work on disparity studies a lot and have worked for dozens and dozens and dozens of programs around the country. And we really have sort of failed in many ways to go and collect the type of data that Julian mentioned that will allow you to evaluate whether or not these approaches are in fact addressing discriminatory barriers and actually getting more work to MW DBEs. So I guess the first thing I would really urge is to try to collect that data. That's a lot easier said than done. Quite frankly, even governments or organizations that have traditional MWBE programs, in my experience, never fully collect all the subcontracting data that you need in order to evaluate the programs. And I think it might be difficult in many places to have the political will and the resources to do that in the absence of a real MWBE program. It's really hard to get it done when people have strong, aggressive programs that they're promoting. But if you don't have that, getting people to pay to implement data collection systems, and there's some very good ones out there. They aren't even terribly expensive, but there is a cost, and there's certainly an administrative and staff cost in time and energy to do this, as well as the fact that you're unhappy about having to provide all of this to you. So if you're going to go down this route, I think you really will have to marshal your political forces to be able to get the type of support that you're going to need and the money to get it done. I think one thing that's really helpful about these types of approaches is if you focus them primarily on prime contracting awards. Even in a traditional MWBE program, there's really very little we can do for prime contracts. We can't do set-asides. The courts will immediately tell you it's a quota and strike you down. We probably shouldn't be doing things like points because that functions like a quota. And so it's difficult to be able to do things that directly help MWDBEs to grow from bidding and proposing merely as subs to doing prime work if that's something to which they aspire. So some of these efforts, things like a bonding program, financial assistance, unbundling, reducing bonding and insurance requirements, all those kind of things are really helpful for MWDBEs as primes, and I think that they ought to be incorporated even if you are doing a more traditional MWBE approach. And then speaking of bonding programs, I mean, I've talked to literally 1,000 MWDBEs over the last few years. And what I hear from them is that more information access is nice, but a lot of them are businesses that have been around for quite some time now and are really sophisticated. But what they need is financing, bonding support to help give them the tools that they lack because of discriminatory barriers in the marketplace. Again, good programs aren't cheap, but they certainly can help, and would urge you all to think about them as part of whatever you're doing. Because in the end, the only thing that really matters is whether these firms get work and they grow. And while things like non-discrimination clauses are nice, nobody really got help directly by that. So I would urge you to focus on the things that provide a direct, immediate benefit to these firms. Then finally, Julian mentioned about when in the U.S. DOT DBE program you might be required to use race-conscious remedies. So just a word about that. Part 26, 2645C tells you how to set your overall annual goals, and under some recent amendments to the regulations, you will be required to explain why you don't meet them if you don't on an annual basis. So the regs do say that you need to use race-conscious measures, which is a fancy way of saying contract goals, if you don't think that you can meet your overall goal through the use of race-conscious remedies, race-neutral remedies. In my experience, the only way you can meet your entire goal through race-neutral measures is if your goal is extremely low and does not, in fact, reflect the availability that you would expect of minority and women firms in a discrimination-free world. So if you have an overall goal of 6 or 7 or 8%, you might be able to meet that through race-neutral measures, but you should ask yourselves whether or not if discrimination went away tomorrow, would 96% or 94% of the dollars in your jurisdiction still go to white males. So with that, I'm going to stop. I see that there are lots of questions in the chat, and we want to be sure we have plenty of time to talk about what you all want to talk about.
Great, thanks, Colette. And we are going to get now to the question time. And we have a bunch of questions in the question box, but we actually prefer if you are able, if you want to raise your hand, you can do that as well, and we can get to you and unmute your phone. We're actually going to start with a couple of the written questions, though. So there's a question from, who's that from? I believe this is from Cheryl Myers. Are there best practices, examples of creating bond, loan, or insurance programs that you are aware of? And maybe we'll start with Julian, and I might be able to fill in too.
I think you, Tim, and Colette are probably best equipped to answer that one.
So there's a number of states. We did a survey of all 50 state governments and their programs, and I don't have them off the tip of my tongue right now, but I'd be happy. I encourage you to look for our 50-state research on our website, and there's a section there on loan and bonding programs, and I think there's some really good examples there. I know locally here in the Bay Area we have a really good example of an insurance program that's working well, both in Southern California as well as Northern California. A number of localities are working with Meriwether Insurance to create more access to or to overcome the insurance guidelines. So I don't know, Colette, if you want to add anything to that. But.
Yeah, I can a little bit, and Cheryl, I can also send you some information directly when we get off of that. I think the thing to keep in mind about bonding programs is that there are really two types. One is a technical assistance approach, which helps you to get ready to get a bond. It looks at your financials, quality control, those kinds of things from the perspective of a surety and asks what is likely to happen to your application. And those are useful, But the more useful programs are the ones that have that component, but also have a surety committed to working with firms that have gone through this program and are ready to get bonded. So it's sort of like the difference between getting a makeover for the prom and then actually getting a date for it too. And getting a date is probably better. So the programs that are the most effective are the ones that actually have that component where there's someone who's going to commit to help to bond you, not just get you ready to get a bond.
And thanks, Colette. We have a question here from Marlene Vick about what an OBE utilization goal looks like. The other business enterprise, an example of that and what data that is based on. And actually the City of Los Angeles would be the best place to go for that more information. And I don't know if either Linda or Keisha from Los Angeles might want to speak to that directly, if you are able to, if you can raise your hand, and if not, maybe we can connect you offline with them for more information about how the OBE program works.
Yeah, in general, I would say that the legal principle in terms of program design about how you would treat OBEs is the same way you would treat MBEs and WBEs, where you would be setting a goal based on some data, a disparity study, and you would look at the particular industry, the type of contracts that are being awarded, and you would have some idea what a reasonable range of the proportion might be. Then you would set the goal somewhere near the low end of that range so that there is flexibility to reflect real-world conditions around a bid. That would be, I think, the strongest way to do it from a legal perspective.
Yeah, this is Colette. I think Julian's exactly right, but the devil is in actually trying to do that. If you don't have a disparity study, you've got to go look for some other data sources. And one of the things that I think is a serious weakness in the whole SBE subcontracting goal or OBE subcontracting goal approach is the fact that, to put an too fine a point on it, and essentially people are making these numbers up because they don't have a data source. One thing you can do is to try to go back to prior procurements of a similar type and see what utilization looked like there. But of course, all that you're doing there is reifying and reaffirming what you've already done, which might not have been right in the first place. I mean, I see this all the time where agencies are just picking numbers out of the air and putting SBE goals on contract that have no relationship whatsoever to what's going on. So at the very least, make sure that your goals reflect what you think are some reasonable subcontractable scopes of the project. Don't just say, we're going to have a 30% SBE goal in every procurement, even when that has nothing to do with it, and maybe 30% is way too high, or maybe 30% is too low. But in the absence of a disparity study, it's very difficult to be able to do this in any kind of a targeted way. So I don't want to suggest that there's some simple way to do this.
All right, so we're going to go now to Los Angeles for a little practical, just how they actually work the OBE goal. This is Keisha Washington from the Mayor's Office for Economic Development.
Hi, yeah, thanks a lot, Tim. This is Keisha Washington. I'm one of the managing directors, and it's actually been my responsibility to help implement our new business inclusion program. With respect to the existing program that does the outreach to the women, minority, and other business enterprises, what we've done there is that is a minimum for outreach. Simply put, we want to make sure, as we're trying to achieve our small business goals, which we in fact want them to be hard goals, we want to have anticipated levels of participation, a different phrase, for women businesses, minority businesses, and other businesses. So when we have given each of our general managers, some of them have hard goals. We've got a difference of opinion in our city attorney's office. So for the proprietary departments, which is easier to speak about, they have a hard goal of 25% of their contracting dollars, not the number of contracts, but contracting dollars with small businesses. Part of the way to achieve that is to do the outreach to women businesses, minority businesses, and other business enterprises. We have essentially giving them a fishing pool with our Bobbin, which is our online electronic platform. We tell them, in order to achieve these goals, this is who you outreach to. And if you are going to achieve your goal through subcontracting, prime contractors, this is the pool from which you must fish. And when you're doing your fishing and you're trying to hit your small goals, your small business goals, which are hard targets, these are the groups that you must talk to. And again, these are the anticipated participation levels. It is true, we don't have any real way of guesstimating what the APL's anticipated participation levels should be for women, minority, and other businesses. We've tried to look at who's in our pool now, and we've got some general numbers, and we have them specifically by NAICS codes. And we could say, okay, based on this particular code, we anticipate that you should, if you're all things being equal, we expect you to talk to this many women, this many minority, this many other businesses. But again, there's a difference, at least in the city, as it comes to a small business goal and anticipated participation levels, which are really our outreach requirements.
Thanks, Keisha Washington. We're going to go to a couple more people on the phone for some more information on some other specific programs. First, I mentioned Meriwether and Williams that has a bonding program. We're going to first go to Victoria Adams, and then following Victoria to Alexander Thomas. I hope Alexander's still on the phone, from the city of Grand Rapids, which has a very innovative program that they implemented following Proposition 2 in Michigan. But first here, Victoria, your phone should be unmuted. If you can explain a little bit more about the insurance program.
Hi, can you hear me?
We can barely hear you. You can either get closer to your phone, perhaps.
Okay, is that better?
That's better.
Okay, hello everyone. My name is Sharon Drake. I actually logged in as Victoria Adams, who is our coordinator for the Alameda County Contractor Bonding Assistance Program. And Meriwether's been specializing in contractor bonding assistance programs since 1995. And we have 6 programs throughout the state of California, 1 here in Alameda County, 1 with City and County of San Francisco, 4 with LA, and 1 in San Diego. And it is exactly what Colette expressed. We help to determine what is precluding a contractor from obtaining or increasing their bonding capacity, and provide them with an action plan on how to overcome those hurdles, and either help them obtain their initial bond or increase their bonding capacity. We've had several successes throughout the last 14 years. We have programs that offer financing options, as well as CPA prepared financial statements. So for each program, the sponsor selects from a menu of our services what they'd like to see offered in their particular county or city.
Thank you. Thank you very much. Now we're going to go to Alexander Thomas. And see, Alexander, if you can, your phone should be unmuted. And if you could explain a little bit, I know that you have like a micro local business enterprise program, as well as something called an equal business opportunity program, and all of these done within the context of Proposition 2, which is similar to Prop 209 here in California. Are you there, Alexander? Maybe we'll come back to Alexander in a little bit. I'm not sure, he may have moved away from the computer for the moment. So we also have a question. I'm going to see if the question from Connie Eng Wang. And unmute your phone here, Connie, to see if you can answer or to ask your question or make your comment. Go ahead. Connie? All right, so we'll maybe try again a little bit later. So some of the other questions here, this one from Debbie Wellnitz. And Debbie is asking about, on Category 1, we talk about outreach to MWBEs is permitted, yet under Category 3, we say that outreach is not permitted. without outreach as well to MWBEs, and it seems a little contradictory there. And so maybe, Julian, you could kind of distinguish between the two types of outreach we're talking about, or the context of that outreach.
Sure. Just to be absolutely clear, the outreach that we're saying we're pretty confident is permitted would be outreach that extends to MWBEs as well as to OBEs, other business enterprises. So that's what we've been calling the inclusive outreach approach, and our conclusion that that is probably permitted is based on some language that was in high voltage and striking down a less inclusive approach, as well as some lower court language about broader outreach there. And of course, the legal argument, as I said, is that that's not a preference because all the groups are being treated equally. Some people have argued that an MBE-only outreach approach might be permitted even after high voltage, depending on exactly what it looked like. You might consider some other creative options that people can come up with to be in Category 2 rather than Category 1. But of the two options, one would be just a straight MWBE outreach requirement imposed on subs, which is what they considered and rejected in high voltage. That would be Category 1, and then the inclusive outreach approach we feel is permitted. I'm sorry, Category 3, as the first one would be impermissible under high voltage, and thus Category 3. And the inclusive approach would be Category 1 permitted, in our opinion. So I guess we should clarify, I know this is a California-centric publication and presentation. The basic rule or language of Prop 209 is similar to the Washington, Michigan initiatives, but of course the high voltage decision clarifying the parameters of that, as well as the lower court opinions that I'm referring to, are California cases. So those would be just advisory to the courts in other jurisdictions.
Thanks, Julian. We have a pair of questions. They're similar, related questions by Marlene Vick, and it's within a small business program that's an innovative program. What has been the MWBE participation within that program? Or similarly, if there's a local small business enterprise program, what has been the MWBE participation? For those places that are tracking that, what kind of results have actually happened as part of that? And I think it, most places that do a LSBE or SBE program are not tracking MWBE, and I think that's part of the point of our presentation, is that they should be. They could doing that. And of those places that are tracking that, I think you've seen really mixed results, and it really depends for each place what's considered, a good result or not, depending on the availability of firms within that area. So to say a certain percentage is sort of meaningless without also talking about what you might expect in a truly in an environment where there truly is no discrimination or barriers or anything like that. So I think it's, if anyone specifically, any program out there who's listening and you want to give some examples within your own program of what some of your MWBE results have been, please raise your hand and we can get to you and have you respond to that question. And Marlene also has a follow-up question. I think this is a very good one. Is data being gathered to see if the various approaches under Proposition 209 are addressing disparity issues? If the proponents of Prop 209 said the purpose was to end discrimination, are there any data being collected to see that it's actually doing that? And her follow-up is, shouldn't that data collection be part of the law itself if you're going to implement such a restrictive program? So maybe we'll first turn to Julian and Colette to talk about that. Personally, I don't think there's... Go ahead, Colette.
Oh, I guess I'll jump in. Julian may be muted out for a second. I think, yes, it would be great if people did that. But in effect, in order to do that correctly, you are really conducting a disparity study. And I think that, as we talked about before, the political will to go and collect data in the absence of a program may be very difficult to muster, since it's so hard to get people to collect it even in the presence of the program. But yes, and those are exactly the types of questions that people need to be asking, the type of information we need to gather to find out whether these race-neutral approaches actually work. And by work, we mean remedy disparities if there are any. Well, in order to find out whether there are disparities, you need the disparity study. So, you know, that's kind of the trap that we're in now, which is we don't have the type of programs that support the need for disparity studies, and you know, it also helps to get the disparity study done right, but that's a different presentation. Without that, we don't have the information in order to know whether this is happening. I guess to the extent that anybody had the will to try to rewrite Prop 209, personally, I just assume we got rid of it. And one thing I meant to say when I was making my initial remarks is that there is a move afoot in California to repeal Prop 209. It's being spearheaded, I think, primarily by the Equal Justice Society under the leadership of Eva Patterson. And people have done some polling about how to present the issue to voters so that they understand that what they initially voted for is not an equal opportunity measure, but is resulting in the retrenchment and the denial of opportunities to women and minorities. So there is some thought out there about getting rid of Prop 209, which ultimately, at least in my view, would be the best thing we could do.
Yeah, so this is Julian. I'm sorry I was on mute before, so you guys all missed my brilliant remarks before. But I certainly agree with everything Colette just said. And we've mentioned several times we are strong proponents of collecting data. I think it's revealing that the proponents of Prop 209 didn't put a data collection requirement in it, and in fact they went through other efforts in court and considered another initiative to just prohibit the collection of data completely, which I think gives the lie to the concept that what they're really worried about is preventing discrimination. It really is about masking discrimination and preventing efforts to address it. And I do think I do think the times have changed a little bit, as much as Pacific Legal Foundation and the American Civil Rights Institute with Ward Connerly are still pushing these things. They're still active in fundraising. If you look, Prop 209 was really passed at a sort of high water mark of polarization and prominence of this issue. This was really obviously being used as a Republican wedge issue. And if you read the majority opinion in the high voltage case, you'll see a great example of a really aggressive effort to sort of demonize and delegitimize the whole concept of trying to focus on the needs of MWBEs. And it reads pretty strangely now, because as much as it's hard to get these efforts in place, and we need to keep always putting the pressure on, it's just not as prominent an issue, and I think not quite as divisive as it was a decade and a half ago. So, hopefully one of these efforts to remove Prop 209 will be successful. And so, props to the voters of Colorado for voting down their initiative.
Thanks, Colette and Julian. And we have time for one last question, and then we're going to make a close here. But from Louisiana, Booker White asks Colette Holt what the average cost of conducting a basic disparity study is.
Oh boy. Well, that's a little bit tricky. It's driven by a couple things. One, how big a jurisdiction are you? How many contracts do you put out? Those kinds of things. And then also what shape your data are in right now. If you haven't even collected MWBE subcontracting data, that will vastly increase your costs. My assumption with clients always is that they won't have collected the non-MWBE subcontracting data. So it's kind of hard to say. For a smaller jurisdiction, you might be looking in the $500,000 range, but it just kind of depends. Also depends what industries you want to include. I always suggest to people that they think about not including commodities, because it's very difficult to set goals on them anyway, so I'm not sure what use this all is. But it's also politically often a non-starter to go back to a major segment of the minority business community and say, we're not even going to study you, let alone include you in a program. But all those kinds of things severely impact costs. If you want the guidelines, which have a lot of detail about that, please just send me an email, and I'll be happy to send them to you, and then we can have more of a conversation about it offline.
All right, thanks very much, Colette. And just one other bit of information that was just sent in just right now on, from San Diego with Rosalind Winstead. She's reporting that recently San Diego started a local small business enterprise program. There was a question about what kind of results have those programs attained, and she's saying in the first year of that local small business program, 73.3% of all construction awards, and I'm assuming that means both prime and sub, but I'm not quite sure, went to Caucasian male-owned firms. In other words, about 27% went to either minority or women-owned firms. That's not the percent of total contracts, that's of contracts within that specific SLBE program. So just to clarify that, there's so that might help give some idea to what you know, a new program can do within a place like San Diego. So and okay, I already said last question. I think this can be very quick with Colette, but is it possible for an agency to conduct their own disparity study, or does it have to be done by an independent contractor? If they already have the data, what would be the downside to an internal disparity study or diversity study?
It's a good question. And let's assume you do have the data, which, as I say, having done dozens and dozens of studies, I would be just shocked if, in fact, that were the case. But let's assume that you do. You could do it yourselves. It seems to me that your problem in litigation, however, is twofold. One, that you probably don't have someone internally that you're going to be able to put up as the type of expert and get qualified in federal court that the judges will take seriously or even allow to testify as an expert. And the other problem is going to be sort of the law of directed results, that if the decision makers, the mayor, your boss, say we want to study and we'd really like to see a program, and then you go and conduct a study and lo and behold, it supports a program, I think your objectivity and credibility would be highly attacked by a plaintiff. But otherwise, I suppose you could do it. I have to tell you, in 20-plus years after Croson, I've never seen anybody do that, but in theory, it is possible.
All right. Thank you very much to Julian Gross. Thank you to Colette Holt, and thank you to all the audience. A very good set of questions and good participation here. And we hope that this has been very informative. And like I said, look for the full recording on our website, as well as our research report written by Julian Gross, the primary author, as well as thank you very much, and have a good Valentine's Day.
Thanks, everyone.